morning.
Good morning.
May it please the court, Keith Upson for Marlon Inman. I'd like to reserve 2 minutes for rebuttal.
Sure.
I want to start by reviewing the state's evidence against Mr. Inman. In part, the state's evidence that was admitted at trial, in part because it's not going to take very long to go through that.
Well, you had the DNA, right?
The DNA on the knife.
What else?
Had the fact that Mr. Inman was romantically involved with Miss Hollis, who had a child by Mr. Elder, Mr. Elder being the homeowner and the roommate of the victim.
The fellow that got attacked.
Yes, sir. Mr. Elder testified that Miss Hollis had texted Mr. Elder about a week before the incident that, and I'm not going to quote it verbatim, but this was the text that she could get grimy with it and send her people over there to do bad things. I mean, that was the gist of that statement. So we have the DNA on the knife, which arguably...
How did that come in? Was that by expert testimony? What did that look like at trial?
I believe it was unremarkable at trial, and I believe being the warning that if the record shows it to be radically different than I expect it to be. But I believe that crime scene investigators came in and they established the chain of custody, and at some point it went to FDLE, and that we had testimony on the...
That it would be 1 in 800 billion or whatever.
Those unfathomably...
So that's pretty strong, even.
It was.
In and of itself is pretty strong.
It was. The DNA on the knife is not a good thing for Mr. Inman.
And the DNA of the victim is not a good thing for the...
Well, of course not. I mean, the injuries themselves. This was a terrifying...
Yeah.
That fortunately for everyone didn't end up any worse than it did.
Of the things that you're taking issue with, what do you think's the strongest?
I think...
The items that came up at trial, there's a couple of hearsay issues. There's the issue of the tape that was...
There are.
Was played. What's your best shot?
I think there's really two entirely separate bases that we're asking this court to reverse. The minutia of air conditioning and hearsay within hearsay, and there were a lot of things, there was a lot of error below. By starting with the state's evidence and acknowledging the DNA on the knife, I want to concede that in a vacuum, all that minutia of error, not to minimize the fact that, as specified in the brief, and I'm not receding from the position taken in the brief, it's going to be harmless. None of that hearsay, none of that gets over his DNA on the knife. So that gets us to that 27-minute interrogation, which was the fourth.
That's what you're mainly hanging your hat on.
And to do that, because counsel objected to it on different grounds.
On Crawford.
Under, was it Crawford?
I recall the objection was based on the violation of Crawford.
To my recollection, Judge, the defense counsel took the position that during that interrogation, Mr. Inman asserted his right to counsel, and that stopped, and that all questioning should have stopped.
And the question was, I want my lawyer in the trial court interpreter to be, oh, you only went it for the blood test, right?
That's correct. And that's not a focus, that hadn't been a focal point of the brief. I didn't particularly find meritorious argument there, having reviewed the same transcript that's contained within the record of that entire proceeding. So as to the DNA on the knife, as it relates to the 27-minute interrogation, I have to come before you and argue it's fundamental to the extent counsel argued at different grounds. He objected on a different grounds.
Yeah, and that brings up an interesting point, because since the objection didn't preserve it, you're going to have to convince me that this is that prejudicial. I mean, there's a series of denials. I understand the officer's trying to interrogate and suggesting that he's guilty, but at the end of the day, all he does is say, no, it wasn't me, it wasn't me, it wasn't me. Why doesn't that help him?
Well, and that may come up later in a 3850 hearing, whether or not there was a legitimate strategic reason to let all that come in. We don't have to go there today because, as I believe it did come up at the time, though I believe it was out of the state's mouth, I believe the statement the state made was that it's not actually a confession or words to that effect, which, as I pointed out in the brief, what about that interrogation then was relevant? If they weren't statements asserting an alibi, which he didn't do, which were later testified to be untrue, if they weren't inculpatory.
It wasn't relevant and intended to have a police officer violate the role of the jury. I'm telling you you're guilty. I'm telling you not to believe him. What reasonable juror would believe your story? Putting the police officer in the jury box. There's a lot wrong with that statement.
And that's...
Okay, it's right, so it's wrong.
And that and the state Supreme Court's decision in Jackson, I believe, is what will convince you, Judge Black.
I was more convinced by the well-reasoned dissent by Justice Kennedy, actually.
No, I can't. I can quote I can stand here and look you in the eye and quote large portions of Jackson. I can quote to you about what was different about Jackson. I can quote to you about the fact that in Jackson, he actually...
They say death is different as well.
Well, and
Jackson was a death
the
case.
point's well taken. But in some ways, the facts in Jackson were worse. But I can't, as I stand here, discuss it's a blank and shouldn't be. But
That's probably not the word to use with Judge Black, that it was a blank.
I can't contrast the dissent as I stand here before you. I'd be delighted to file something. And that's an oversight I don't think I'll repeat. But those were essentially the four. Those were the four, starting with the knife, and the fourth incriminating evidence being the DNA. And just by way of example, when in the brief I talk about the fact that this court's decision in Fleming holds that it was improper to allow Ms. Hollis's alleged statement to show Mr. Inman's motive. And that objection was made and that issue was preserved. There's one of the four things. Now, I appreciate that this isn't trial by oath or trial by oath taking, and it's not a matter of how many pieces of evidence, because there's still the DNA on the knife. But a little closer examination then at Detective Moody's interrogation and the majority opinion in Jackson, acknowledging that death is in fact different. That opinion being published in November of 2012. Just like in Jackson.
Subscribed to by a majority of the court.
Right. I was just having some fun.
I know, I'm just teasing, you know.
And I should have. See, if I could say, well, here's what's different. Here, look, even to his dissent, and if I could use the dissent to persuade. But
anyway, so I think I got it. You know, there's not that much in this, really. Your brief is to the point. You've got a few concerns about the way the trial went. Although, honestly, keeping the jury to midnight, if that was reversible, then I would have been in a lot of trouble, and Judge Casanova probably would as well. But what else?
Well, if I could, some of the high points from Jackson that are factually similar here, if I could. And Judge Casanova, you touched on this, on the testimony of the detective. That was Detective Moody's testimony, out-of-court testimony in this recorded statement that was played for this jury, that he never could have taken the stand and testified to those things. It would not, and he did not in this case. That parallel Jackson, the detective in this case made repeated expressions of Mr. Inman's guilt. As in Jackson, the detective's statements didn't provoke any relevant responses from Mr. Inman. It never got anywhere. As in Jackson, the detective's statements never resulted in an admission of culpability. As in Jackson, the detective's statements constituted opinion testimony that invaded that province of the jury.
The question I have, even assuming under Jackson, if the test here is fundamental error, is this going to be better handled in a 3850 proceeding? Because I know there's at least one case out of Pinellas County where a member of this court wrote a reversal because the lawyer didn't look at the tape or keep it out.
Obviously, my position is, let's just deal with it now. And I try and, like the poor chess player that I am, I try and play that through how this is going to go. This was tried in October of 2012. Jackson was published in November of 2012, rehearing denied in January of 2013. Now, I'm not going to quote the authority that's quoted within Jackson that existed prior. It's not in my brief, so I'm not going to. There was a basis there.
Wasn't there also a proper objection in Jackson?
There was. It was not a fundamental. The issue for the Jackson court was it fundamental? The Jackson statement arguably.
I mean, that's a big difference, isn't it?
It is a big difference, but there were things about the Jackson statement. For example, the bulk of what he said, Jackson said, later changed his story, which is evidence of guilt. Further, in Jackson, they didn't have what I've raised as a Williams rule, some of the statements that Detective Moody, would you tell me if you had, and of course I'm paraphrasing, so whatever, would you tell me if I had? Yeah, I would have told you if I had. Well, have you ever told them any other times they've questioned you? I'm shivering as I stand here and say that was played for the jury. That wasn't present in Jackson. But some of the statements Detective Moody, and of course these are my favorites, and it's page 10 of the initial brief. I miscited the transcript. I cited 677 to 673, which is, I hope, obviously an error. It's 677 to 683. You're the one who did it. You're not going to court and say, I didn't do it. Your lawyer cannot defeat DNA. You cannot defeat that. It's our position that on the facts of this case, DNA on the knife's really bad. Not really a slam dunk other than that. I mean, it doesn't have to be. DNA on the knife could be enough, could be sufficient. But in the context of that being the state's evidence, allowing this detective to testify about those ultimate fact issues, this is one of those rare situations. This is what fundamental error looks like. And we'd ask the court to reverse and remand for a new trial. I started to say how I see this going on 3850. You bring it up below. Circuit judge says, what were the cases he would have argued at the time without Jackson? Looks at those. Because it's our position, Jackson ties together these, they're similar, but
strands.
Exactly. Says, I'm going to deny it. How could he have argued on a basis that didn't really exist at the time? It comes back before this court on review, with or without hearing below. And Mr. Inman, with or without counsel, is presenting the exact same argument that I'm presenting to you today. So let's just deal with it now, please.
Thank you, Mr. Upson. You have about 5 minutes left.
May it please the court, my name is Marilyn Becchio and I represent the state of Florida. As this court is aware, certainly there was no objection based on Jackson or Miranda or anything else below regarding Mr. Inman's statement. And I'll address first why it was relevant, although not inculpatory. And it was relevant to, in part, establish the relationship between Ms. Hollis and Mr. Inman to make the connection as to why his DNA would have been on that knife, that he had never been invited to that home before, and that the motive and the intent was developed through this animosity between Mr. Elder and Ms. Hollis.
So there was no attempt to redact?
There was no attempt to redact. And the motion to suppress was in relation to a invocation of counsel that the court found was related to only the DNA test, which is where he says, I'm not going to let you swab my mouth until I talk to a lawyer. And I'm paraphrasing, but essentially that's what it was.
You know, under Miranda, under Miranda and all the years since, the instruction is basically, you've got the right to speak to a lawyer before questioning. You've got the right to speak to the lawyer before answering any specific question. Why isn't there an analogy there? You've got the right to speak to a lawyer before you allow a DNA swab, but once that invocation happens, they can't go forward. So if you have the right to if you can invoke the right to counsel before answering a specific question. The officers can't say, okay, well, we'll ask you a different question. They have to stop.
And I could be wrong, but I don't think they did in this case. That request for the DNA swab came well into almost at the end of this conversation that they had. And they didn't ultimately,
So you're saying that there was nothing that happened thereafter that would have been inculpatory?
Not that I can recall. And really none of his statement was inculpatory in the sense that he admitted any kind of involvement with the crime. He continually denied that.
What the judge really would have said, I think, correctly under Miranda was any statement after that invocation would be out, even though there wasn't anything, but everything that came before the invocation is in.
I mean, I think arguably that could have been a ruling, and that we would probably be standing here arguing about that if that indeed were the ruling. But I wanted to address some of the Jackson issues that have been raised. And although the detective in this case does talk about DNA evidence and the strength of the DNA evidence, he's not presenting to Mr. Inman or to the jury any evidence that they weren't presented at trial. They were given the DNA evidence. It wasn't as if he was implying that the police had other evidence that inculpated.
But how about, the officer is also commenting about, you can't go to court and deny this. Your lawyer's not going to be able to deny this. And so the jury is being told, essentially, they can't present a defense, and of course he can't deny it. If he doesn't take the stand, isn't he disproving the detective's point?
Well, obviously he did go in and essentially deny it by having the trial.
Right.
And I think the concern with Jackson, and one of the things, if I'm recalling correctly,
he made the state put the proof.
Sure, and it was challenged. I mean, his counsel challenged the DNA evidence on a number of different grounds.
He also took the stand, didn't he, Inman?
He did not.
I was thinking he did.
I don't believe he did. I'm sure
and
counsel
I frankly don't remember. But whether he did or not,
Right.
that characterization and comment, even if he took the stand, it perhaps is even worse because you have the officer, the detective, characterizing his testimony.
Well, I think part of
jury.
the issue in Jackson as well is that juries recognize that police have certain tactics that they use in order to develop.
Right, but you don't play them to the jury.
Well, you can. If it is something that the jury would understand is a tactic that the police use and they're not taking it for the God's honest truth. They understand that
was there an instruction to them in this case?
I don't believe so,
Or
no.
probably not one requested either.
No, I don't think so. And whether or not this was a strategic or tactical decision for counsel to allow some of this evidence to come in, particularly the statement, I mean, the fact that I can think of strategic and tactical reasons why he would want to do that leads us to believe that this should be addressed at a 3850 if at all. I understand Mr. Upson's concern about, did you ever admit anything previously, when they've asked you? And we don't define who they is. We're not saying when the police have interrogated you previously, have you admitted to a crime? That's not what he said.
Not expressly, but it's fairly.
No, but
contextually, it's.
And I think, there are defense counsel who will come up here and say that I allow that kind of evidence to come in to show that when he does something wrong, he admits it.
Right.
And because
sometimes they actually put that
Correct.
testimony on. For
Correct.
Sure.
So, we don't know whether that was the thought process in this case, but that's why we have, evidentiary hearings on 3850s if it should come to that. And I think Mr. Upson's overall concern with a due process violation, although maybe not the best trial that anyone's ever read, it's certainly not the worst. There's not a constitution. Yes, there sadly are, Your Honor.
If you had to pick the worst, I think I was involved in that one, but
well,
not as a judge.
Well, and that's why we always say hindsight is 20/20. Right. I mean, we can look back and decide that maybe I would have tried this case differently or put on different evidence or challenged the evidence in a different manner. But, Mr. Inman also, I believe, had the same counsel previously when he had his case mistried. So, I mean, there's some benefit maybe to how counsel chose to try this case. But the real question is, was there a due process violation? And as we know, due process, requires that a criminal defendant has a fair opportunity to challenge the state's case against him. And Mr. Inman was given that fair opportunity. He's entitled certainly to a fair trial, but not a perfect one.
Can I ask you this? What about the state obviously put on the DNA. And the fact that the knife that was used, I believe was established, it was from inside the place where the crime, it didn't come from outside in. So there's no really good explanation as to how Inman's DNA would be on this knife. What else did the state offer by way of proof? This three-party relationship, I guess?
Essentially, yes.
What else? Is that just
really
basically-
that's it. The DNA and the motive as far as the relationship between Hollis, Inman, and Mr. Elder.
that Inman was now dating the mother of Elder's baby.
At the time of the offense, correct, yes.
And
It
the
came out
offense
that-
occurred in the home of
In Elder's home.
Mr. Elder,
Elder's home.
But
was
but
the-
Elder wasn't the guy that got whacked. It was
Correct.
the other guy.
correct, his roommate.
Okay. But Hollis is the mom?
The
Yes.
mom.
Was she ever in there?
Previously, she had stayed on and off with Mr. Elder when their son was born, but it had been
Was
a
there-
month or few months since she had been there, because they had
Was the son ever in there?
the son of Mr. Elder
right.
and Miss Hollis. Yes, the
And
baby
can
and
a-
Miss Hollis did stay on
And
occasion
can
with Mr.
one
Elder.
person transfer the DNA of another person to another place?
The son is Mr. Elder's son, not,
No,
Mr. Inman's son.
Miss Hollis.
I'm sorry, repeat that.
Miss Hollis is the girlfriend
Correct.
of the defendant,
Mhm.
and she's been there.
Not in relation to when this occurred.
Well,
Not
we
for-
don't know how long the DNA was on that knife.
No, but we also know that, I think even through Mr. Inman's own statement, that he and Miss Hollis had known each other previously, but then they had not dated for a while, had not seen each other for a while. It wasn't until she moved but moved back to, I think it was Brooksville from Tampa. She had no longer been seeing Mr. Inman, that they reconnected. So there was no indication that they had a relationship at the same
the time.
time that she was living with Mr. Elder,
And
although that was...
and
But-
that wasn't a suggestion in the record as to an explanation for the DNA.
It was sort of, defense counsel did try and imply that maybe there was a way that
Some
Ms. Hollis, or that Ms. Hollis planted essentially the DNA, or
Because
someone
the-
else
because-
planted DNA.
Because it strikes me, I mean, we're sitting here, and counsel has acknowledged that DNA is very powerful
Mm-hmm.
evidence, and a lot of this fades to the wayside in light of it. And yet, there was a mistrial in the first case. The jury
Yes.
was hung.
Mhm.
Why was that? State had the DNA then.
I
Right.
couldn't
I mean,
venture a
so,
guess.
Yeah. So,
but the point is really, and we're talking about due process and ineffective assistance of counsel issues, he did try to, and DNA is difficult to address,
and
there's
he
no
made
doubt
an
about it.
effort.
He made an effort
Couldn't just-
to establish that DNA could have gotten on that knife in a different way. Unfortunately, the other evidence didn't really help him support
match
that
up to it.
argument, but there was an attempt at least made. So I think as we stand here today at this juncture, the state would ask the court to affirm both the conviction and the sentence, and should other proceedings occur, then we will address them as they come.
Thank you, Ms.
Thank you.
Mr. Upson, what did I say, you still have about 5?
You said 5.
Yeah.
I was grateful. I was originally going to say I don't think I'm going to use all my time, and then I proceeded to use more of it than I
Right.
thought I was going to. So
You were still within the rules.
I don't know everything that was different about the first trial. I haven't read. I did, as a supplement, have some of that mistrial portion transcribed because I was looking for something that I didn't find.
Well, it just strikes me that the DNA evidence would seem to be like an overwhelming problem, and yet the jury couldn't come to the verdict the first time.
One thing that I do know is different about the first trial was Ms. Hollis testified
Okay, and was
And was-
cross-examined in that trial.
and was subsequently charged with perjury,
Right, changed her story, yeah, okay.
Because they were trying to get her testimony into this trial.
and they tried to
And
get
they-
the
and the judge kept it
transcript,
out.
which was an issue that was preserved and which has been briefed, not one that I would waste any of the precious time this morning.
Well, I'm not sure, because she now says she lied during that trial, and she's being prosecuted, and of course, she's not gonna get on the stand in this case, given that. But why didn't that just go to the credibility of her testimony?
Which I
As opposed
asserted in the brief. So this is a fact issue
Because
for the
defense
jury.
moved to put the transcript from the first trial into evidence.
Just her testimony.
That's what I mean.
Including the cross, if I remember correctly. They weren't trying to alter what had been presented, and I think they made the argument under the unavailability. I think they made the argument. And of course, in the brief, I said, well, this is going to be easy then. Every time the state gets a mistrial, just charge the defense star witness with perjury, and when it comes back for retrial, they can't poof. The defense star witness can't come testify. And surely that can't be. But I think it's a fact issue, and I said that in the brief. Tell the jury this is the testimony. Tell the jury she's currently under prosecution for...
Tell the jury she's recanted.
And use all that, because the jury should be deciding that. They should be weighing those. It's credibility, not admissibility. I don't know what else was different about the first trial. I know that one thing that was different was she testified. One of the other statements the detective made, and that's, unless the court has more questions, that I didn't read a minute ago. At least I think I didn't read it, so I apologize if I did. The only way your DNA could be left in that house, the only way that happens is when you're stabbing him, you cut yourself. That's the only way that's going to happen. It strikes me how similar that sounds to a jury instruction that's already been checked. If you just add, if you find that, and you change the language a little bit, because he was charged with burglary of a dwelling with a deadly weapon and the robbery with a weapon, at least that's how they convicted. That statement that Detective Moody made reads almost like the jury instruction with the difference, or the verdict form, with the difference being Detective Moody in that out-of-court statement was already, it became an affirmative statement of fact. That was, it's our position, fundamental and sufficient. And if you play it through, there were plenty, I don't want to beat that point completely into the ground either. There were ineffective assistance of counsel issues that I think would merit hearing in the circuit court. But my concern is that we'll end up in the exact same place, having the exact same discussion 6 months, 12 months from now. If the court doesn't have any other concerns or questions, now of course the first thing I'm going to do is go read that dissent. and I'm going to want to file, but I'm not.
Send a letter. So.
Thank you.
Thank you both very much.